Are you curious about the mortgage foreclosure process in Pennsylvania? If so, I'm attorney Sean Mays. I'm a foreclosure attorney in Pennsylvania. Stick around and we'll give you a little bit of the basics about what a foreclosure is and how the process plays itself out. So if we haven't met before, my name is Sean Mays. I'm an attorney in Pennsylvania, and I help people deal with debt and debt-related issues like foreclosure and bankruptcy. Today, I'm just going to stream live a little bit and just give you some of the basics of the foreclosure process in Pennsylvania and how that foreclosure process plays itself out. If you have any questions or concerns, feel free to put those in the comments below. And if you want to suggest any other topics, just please let me know. So foreclosure in Pennsylvania is a judicial process. Throughout the United States, there's basically two types of foreclosure processes. There is a non-judicial foreclosure and there's a judicial foreclosure. In a non-judicial foreclosure, typically in those states, a lender can just proceed straight to a foreclosure sale without any intervention by the court. In Pennsylvania, however, we are a judicial foreclosure jurisdiction, and what that means is in order for a bank to foreclose on the mortgage and put that property up for a foreclosure sale, the bank first has to go to a court and get a judgment, and then once it obtains that judgment, then it can list the property for foreclosure sale and proceed with the sale of the property. So in Pennsylvania, a mortgage foreclosure is very similar to any other lawsuit. It starts the same way. Foreclosure starts by the bank or the mortgage servicer filing a complaint in the Court of Common Pleas, and that complaint is going to be filed wherever the property is. So regardless of where you live, the complaint is going to be filed where the property is. So if it's a vacation home or a second home, that foreclosure complaint is going to be filed where that home is. Once the foreclosure complaint is filed, the bank's going to serve it on you. In Pennsylvania, we require personal service, except in other certain circumstances, like if you live out of state. And that means that the sheriff or sheriff's deputy is going to come to your home and serve you with a copy of the complaint. If they can't get service on you, it doesn't mean the case is over. It means that they're probably going to go back to the court, explain how they can't get service on you, and ask to get service by other means. So they'll typically get service by publication in the newspaper, by certified mail, and by regular mail. Once that complaint is filed, it proceeds like any other lawsuit. So in Pennsylvania, you have 20 days from when the complaint is served on you to answer the complaint. If you don't answer the complaint, the plaintiff has to give you an additional 10 days notice, warning you that you haven't answered the complaint, and if you don't answer within the next 10 days, then they may proceed to judgment. Now that's as quick as it can. Sometimes either the bank or the attorneys aren't as quick filing the paperwork, so just you may have 30 days, but the bank may take longer in getting a judgment. But that's the quickest that they could possibly go. If you don't answer the complaint, then what happens is the bank gets a default judgment, and then the bank can immediately list the property for sheriff's sale. If you do answer the complaint, then the case is litigated like any other case. And in Pennsylvania, you can answer a complaint by filing an answer, which is responding to the allegations in the complaint, or you could file what we call preliminary objections, and that is similar to a motion to dismiss in the federal courts. Not quite the same, but it's essentially saying that the complaint doesn't comply with court rules, or it doesn't set forth a valid cause of action. There's a number of different things you can raise in objections. Then those objections would be heard and either sustained, which means that the plaintiff has to either amend the complaint or correct the deficiencies, or they'd be overruled, and in that case you'd have to file an answer. When you file an answer, once again, you're basically either admitting or denying the allegations in the complaint. And also with that answer, you have the opportunity to file any kind of affirmative defenses that you might have. And there actually are several different affirmative defenses that are applicable to mortgage foreclosures. For instance, if you're going to set out that the mortgage bank didn't comply with Act 6 or Act 91, which are the pre-foreclosure laws in Pennsylvania, or if you're going to set out that they didn't give you proper notice. If they didn't accept payments, let's say they miscalculated payments or added illegal fees. I mean, any affirmative defense that you're going to set out, you set that out when you file your answer, and they call that new matter. So you would have a section of your answer which is admitting or denying allegations in the complaint, and then you would also have a section in your answer setting forth your affirmative defenses, or what the rules of civil procedure would call new matter. Once that procedure is done, once the pleadings are closed, then it proceeds to discovery, and that's your opportunity to get documents from the bank, to send document requests, to send interrogatories, and depositions if you're going to take depositions. And that would be, once again, just like any other lawsuit. It's an opportunity to exchange discovery. Then it would proceed either to trial, or typically mortgage banks in Pennsylvania would file what's called a motion for summary judgment. And essentially, that's a motion to the court asking it to make a decision without a trial. That's the simplest way of putting it. Typically there's a lot of case law behind that, but typically most litigated cases are resolved by a motion for summary judgment unless a defendant can not only put up a defense to a foreclosure but provide adequate proof of the foreclosure. Then typically a case would be resolved by a motion for summary judgment. If the borrower can put up proof that there's issues of fact surrounding the defenses to foreclosure, once again, if they can show that the noticing was improper, if they can show that the bank didn't follow the contract and the mortgage documents, anything along those lines, if they can provide evidence of that, then the case would proceed to trial, and it would have a trial before a judge on the merits. Now, depending on the outcome of that trial, if you lose, you would have the opportunity to appeal it. And if you win, obviously the case would be, the bank would have the opportunity to appeal that as well. If you do lose, though, the bank could then proceed to filing a judgment and getting a writ of execution issued and listing it for sale. One of the questions that I get asked quite a bit is, how long does this process take? And their short answer is, it depends. It can take anywhere from a matter of a handful of months to a matter of a handful of years. And it really depends on, number one, if you let it go to a default judgment, obviously it's going to be a very short case if you don't file any kind of answer. Number two, it depends on the extent to which you litigate it and the extent to which you conduct discovery. Simply filing an answer will prolong the case, but if you actually undertake discovery, if you actually request documents, if you can demonstrate that there's issues of fact about your defenses set forth in your answer, a litigation, depending on the county, can last well over a year. I've seen it last 2-3 years, depending on the issues raised in the case. Assuming a case goes to a judgment in favor of the mortgage bank, after that, you're generally looking at about another 4 months or so between the time period of when a judgment is entered and when a property would go to sheriff's sale. So during that time, there's a lot of things you can do. If you are trying to work things out, that obviously gives you plenty of time to try to apply for a loan modification with the mortgage lender. If you're considering bankruptcy, or if you had any kind of setbacks financially and you're trying to get back on your feet, that gives you a time frame. Litigating the foreclosure gives you a time frame to get back on your feet financially, at which case you could either reapply for a loan modification or consider a Chapter 13 bankruptcy to reorganize your mortgage. But in a nutshell, that's the foreclosure process. Like I said, generally, depending on if it's litigated or not, it can last anywhere from a matter of a few months to a matter of years. And how long it lasts really depends on a specific factual analysis of the case. But on average, a typical foreclosure in Pennsylvania that's contested lasts well over a year. So once again, I'm attorney Sean Mays. Those are just a couple basics about how foreclosure proceeds in Pennsylvania. If you have any questions or comments, feel free to post those below, and thanks for watching.